Hi, I'm Alan Beaver. Welcome to this episode of Understanding Tort Law, the Law of Private Nuisance. So in this episode we're going to do something a little bit tricky. We're going to look at five cases from around the common law world. And there's something very interesting about these cases. One is, at one level, at a very obvious level, a level that I'm sure you'll all notice, these cases are all exactly the same. But at another level, these cases are very different with each other. In fact, they conflict with each other. And understanding the nature of this conflict is going to help us understand the rest of the material that we need to look at, not only in the law of private nuisance, but throughout tort law. Because what we're going to see here in these cases is very different understandings about what the judicial role is, very different understandings about how to decide nuisance cases, very different understandings about what this area of the law is all about. Okay, so our first case is the decision, a very famous American decision of the Florida District Court of Appeal in Fontainebleau, Fontainebleau Hotel Corporation versus 4525. Okay, now what happens in this case is that there are two hotels. Obviously this isn't the best picture, but you can see here three hotels. The one on the left is not of interest to us. It's the one in the middle, which is the Fontainebleau, the defendant hotel in this case, and the one on the right, which is the plaintiff's hotel. These hotels are situated on the Miami Beach Strip. They're next to each other. And one of the hotels, the Fontainebleau, wants to build an extension. They want to build up. Now, the problem for the plaintiff is that if the defendant does build up, this will cast a shadow over the plaintiff's property, specifically over the pool and cabana area in the afternoon during the winter and spring months. Now, on the face of it, these people who live in the part of the world that I live in might think, what's the problem? People don't go swimming in the winter. But in Florida, this is when people go swimming. In the winter and the spring, this is when people flee the freezing parts of the United States to come to Florida. And when they go to Florida, what they want to do is they want to sit around the pool sunbathing. But they won't be able to do this if the plaintiff builds up and if the defendant builds up, and a shadow is cast over the plaintiff's pool and cabana area. So they're very worried about this because they think it will lead to a loss of patronage. And so they go to court seeking an injunction, alleging that there has been a nuisance. Now, at first instance, this is the trial. The case that we're looking at is an appeal, right? It's a decision of the Court of Appeal. At trial, the court found this. The court said, in granting a temporary injunction in this case, the court wishes to make several things very clear. The ruling is not based on any alleged presumptive title nor prescriptive right of the plaintiff to light and air. It is based solely on the proposition that no one has a right to use his property to the injury of another. In this case, it is clear from the evidence that the proposed use by the Fontainebleau will materially damage the Eden Rock. Okay, the Eden Rock here being the plaintiff's hotel. Okay, so the trial court said, look, there's a principle that you can't use your property in a way that injures the property of another. If the defendant builds up, this will injure the plaintiff, so we mustn't allow the defendant to continue. Now there's a maxim here. I'll just put the maxim up, this Latin maxim that you can see here. Now when this maxim is translated into English, it means one must not use one's property in a way that injures the property of another. So this was the principle to which the trial court was appealing. However, the Florida District Court of Appeal is totally unimpressed by this argument. They say, this is indeed a novel application of the maxim. I mean, here, the maxim means, remember, don't use your property in a way that will injure the property of another. But they say that's a novel application. of the doctrine, the maxim does not mean that one must never use his own property in a way such as to do an injury to his neighbour, despite what the maxim actually says. It means only that one must use his property so as not to injure the lawful rights of another. So in other words, and this is something that you have to get used to when you study law, you can't take maxims at face value, and this is particularly true when they're Latin. If you want to understand what a Latin maxim means, it's often totally misleading to take that maxim and to translate it into English. It will mean something, it could mean, often means something quite different. So here the court's saying, look, the maxim might literally, if it's literally translated, it might mean don't use your property in a way that injures another, but that's not what it means in law. What it means in law is that you're not entitled to use your property in a way that will violate the rights of another person. The court backs this up by quoting the following. It is well settled that a property owner may put his own property to any reasonable and lawful use, so long as he does not thereby deprive the adjoining landowner of any right of enjoyment of his property, which is recognised and protected by law, and so long as his use is not such a one as the law will pronounce a nuisance. And so the question here is not whether if the defendant's building goes ahead, the question is not whether the plaintiff will suffer some kind of injury, some kind of loss, whether people will be deterred from making bookings and so on. The issue is whether there is any violation of the plaintiff's rights. So what we need to look for is a rights violation. The plaintiff needs to argue, if the defendant, if you build up, you will violate our rights. If the plaintiff can show that, then the court will stop the defendant building. But if the plaintiff can't show that, then the defendant can go ahead. So the question then is, has a right in the plaintiff been violated? Now, the court searches around for a right, but the only right that they can find, the only suggestion of a right that they can find is a right to sunlight. So if the plaintiff has a right to receive sunlight, then the plaintiff will be able to argue, right, I have a right to receive the sunlight, your building up will block the sunlight, so you're interfering with my rights. The problem is, as the court notes, there is no such right in American law. As they say, no American decision has been cited, and independent research has revealed none, in which it has been held that, in the absence of some contractual or statutory obligation, a landowner has a legal right to the free flow of light and air across the adjoining land of his neighbour. Even at common law, the landowner had no legal right, in the absence of an easement or uninterrupted use and enjoyment for a period of 20 years, to unobstructed light and air from the adjoining land. There being then no legal right to the free flow of light and air from the adjoining land, it is universally held that where a structure serves a useful and beneficial purpose, it does not give rise to a cause of action, either for damages or for an injunction. So the conclusion then is that although the defendant's building up may cause some loss to the plaintiff, it may cause some financial damage, there is no violation of any right that the plaintiff had. There would be no rights violation, and so the Fontainebleau is permitted to build up. Now, you might say, okay, all right, I see this, I see the legal argument here, but what about public policy arguments? Well, the court addresses public policy arguments, and they address it in this way. They say, if, as contended on behalf of plaintiff, public policy demands that a landowner in the Miami Beach area refrain from constructing buildings on his premises that will cast a shadow on the adjoining premises, an amendment of its comprehensive planning and zoning ordinance applicable to the public as a whole is the means by which such purpose should be achieved. So what the court's saying here is this. They're saying, look, it may well be that there are public policy arguments that are relevant here. It may well be that the public policy arguments argue against the defendant being able to build up. That may or may not be the case. The point is, a court is not the right place to hear those arguments. The right place to hear those arguments is something like a local council. So you go to the city council, you go to the local council, the district authority, whatever it is in the particular jurisdiction that you're in, and you ask the councillors there to pass a bylaw of some kind protecting your right to sunlight, and indeed in this case it would be everybody's right to sunlight. And in that forum, the arguments can be raised, the public policy arguments can be raised and challenged by various interested parties. But in court, says this court, public policy arguments are irrelevant. Our job is to determine whether there has been any violation of the plaintiff's legal rights, or would be any violation of the plaintiff's legal rights. Our job is not to determine public policy issues. Public policy issues may be important in this case, but they are for democratic institutions to determine. We are not such an institution. Okay, so this is not a rejection of the relevance of public policy, but it is a rejection of the relevance of public policy in court. Right? It's relevant, but it's not relevant in court. If you want to advance a public policy argument, that's fine, but you have to go to a democratic institution to do so. Okay, so just to briefly summarise Fontainebleau. One is entitled to use one's land in a way that injures another, as long as one doesn't injure their rights. So the issue is whether there's a rights violation, not whether there's a causing of loss. There is no legal right to sunlight, and so in this case, or any other relevant right, so in this case the plaintiff loses. The defendants building up would not infringe any right in the plaintiff, and so the plaintiff was not entitled to an injunction to prevent it. Public policy is relevant, but not relevant in court. It may be, for all we know, against public policy to allow hotels on the Miami Beach Strip to build up. Amazing. I mean, that can't be right, I would have said. But you know, maybe there's some public policy issue there that I don't understand, and building of this kind should not be allowed. But if it shouldn't be allowed based on public policy arguments, then you have to take those arguments to a democratic institution where they can be heard in the appropriate fashion. It's not for courts to, according to this court, it's not for courts to determine these issues, not for unelected, unaccountable judges to determine those matters. Okay, that's our first case, Fontainebleau. Now, our second case. Okay, this case is Bryants and Lefevre, a decision of Justice Bramwell, Lord Justice, as he is in this case, Lord Justice Bramwell. Whether one likes his judgments or not, no doubt one of the greatest judges in the history of the common law. So what happens in this case is that there are two neighbours, and the defendant decides that he's going to build up. And as a result of building up, so the wind patterns have changed, and the plaintiff's chimney begins to smoke. So he used to light his fire and everything was fine, but as a result of the defendants building up, the wind patterns have changed, the little eddies or whatever there is around around their properties, and as a result, when the plaintiff lights his fire, the fire smokes. So smoke comes into his house. Now, to us today, that mightn't sound like a huge deal, but at the time, it probably was a huge deal because this is how people heated their homes. And so the plaintiff is faced with a very difficult choice. He either lights his fire and gets smoked out, which is a problem, or he freezes. Right? So it's a big deal. It's a big issue for him. It's like not being able to use your heating in the winter. Okay, now, what does the court say about this? This is how Bramwell starts. Now, you have to be careful here because Bramwell is playing around with the word nuisance a bit. You know, as we saw right at the beginning, the word nuisance has various meanings. It can mean something being annoying and something being a legal nuisance. And Bramwell is playing with this meaning. Anyway, let's see what he says. He says, "No doubt there is a nuisance, but it is not of the defendants causing. They have done nothing in causing the nuisance. Their house and their timber are harmless enough. It is the plaintiff who causes the nuisance by lighting a coal fire in a place where the chimney of which is placed so near the defendant's wall that the smoke does not escape, but comes into the house. Let the plaintiff cease to light his fire. Let him move his chimney. Let him carry it higher, and there would be no nuisance." When Bramwell says that there is a nuisance and the plaintiffs cause it, what he means is that there is no legal nuisance. There is a nuisance in the sense that there's something annoying here, but it's not a legal nuisance. He's not really claiming that the plaintiff is committing a legal wrong against the defendant. Right? The defendant's unaffected by all of this. Right? Right. So there's no nuisance. Why is there no nuisance? Because according to Bramwell, the nuisance is caused by the plaintiff. The annoying thing is caused by the plaintiff lighting the fire. The plaintiff doesn't have to light the fire. The plaintiff might be very cold, it might be very uncomfortable in his house, but the plaintiff doesn't have to light the fire. Right, we'll come back to this. The other thing that that Bramwell says is that the defendant hasn't done anything. Right? What causes the house to smoke is the plaintiff lighting the fire. Not really convinced that argument is a good one, but we'll revisit these and similar issues later. It's more important to look at what Bramwell goes on to say. He goes on to say, who then causes it, the nuisance? It would be very clear that the plaintiff did if he had built his house or chimney after the defendants had put up the timber on theirs, and it is really the same, though he did so before the timber was there. What Bramwell is saying is if the defendant's house, as it is now, had been like that all along, and the plaintiff had then come along and tried to light a fire, and it had smoked, we'd say, well, that's just your tough luck. I mean, your chimney smokes, your fire smokes. You'll have to move your chimney. What makes it a little more difficult to see in this case is that originally there wasn't this problem at all, and the problem occurred only after the defendant builds up. But Bramwell says that doesn't change anything at all. Now notice then the implication here. Bramwell is saying it doesn't matter who got there first, right? Because he's saying the situation is the same. It doesn't, if the defendant got there first, if the plaintiff got there first, the situation is the same. So he's firmly in the camp of it doesn't matter who got there first. Okay, going on through his judgment, he says, but what is in truth the same answer? If the defendants cause the nuisance, they have a right to do so. If the plaintiff has not the right to the passage of air, except subject to the defendant's right to build or put timber on their house, then his right is subject to their right, and though a nuisance follows from the exercise of their right, they are not liable. I hope you can see the connection here between Fontainebleau and Bryants and Lefevre, because the courts are basically saying the same thing. And I think this is the real answer, or the real theory behind why the defendant succeeds in this case. Remember the stuff right at the beginning where Bramwell is saying it's really the plaintiff who causes the nuisance, not the defendants. We think, well, I don't really know how that argument is supposed to work. I think this is the real argument. The real argument of Bramwell's is that the defendant is not guilty of a nuisance because the defendant is not violating any right that the plaintiff has. Right? If we have to hunt around and try and find a right that the plaintiff has that the defendant is violating, and we can't find any. Right? The plaintiff is saying you're causing me some loss. Right? My house is getting all smoky, or I'm cold. Right? But what we can't find is a right that the plaintiff has that the defendant is violating. And so there is no liability. So this case is very much on a par with Fontainebleau. The cases are very similar. Right? In both cases, the defendant is building up. In both cases, the plaintiff complains. In both cases, the plaintiff loses because the court can't find any right in the plaintiff that would be or is being violated as a result of the defendant building up. Okay. Now, I just might note in passing here that if you look in the extracts that I provided for you, there's basically a paragraph. Bramwell's judgment is a paragraph. That is his whole judgment. His whole judgment is contained in that single paragraph. I've just cut out some citations, which is utterly remarkable when you compare it with modern judgments. When we get to the end of this section, that is at the end of our discussion of private nuisance, we're going to be looking at cases that are 50 pages long, and I've read a tort case that's 300 pages long. Bramwell manages to do this in one paragraph, and I think it's utterly extraordinary. It's something that we need to think about. We need to come back at a later date, because we are going to discover the reason for this. Why is it that judgments in the past could be so short, precise, and to the point, and judgments today are so long-winded, waffly, and totally inaccessible to the general public because they are so full of jargon. And frankly, you'd have to be very committed. You have to get paid for it, really, to want to, if you do want to, hunt your way through the entire document. So what is it about law that has meant that it's gone from precise, well-defined, concise material to a judgment that's about the size of a small book, or even not a small book? What's happened? Because I think something serious has seriously gone wrong with the law here. That's my view, of course, as always. It's up to you to decide. We're going to discover what that thing is, in any case. Anyway, that's our first two cases. Okay, so our next two cases are so very different from what we've seen before that I've decided to change my shirt. Okay, in this case, the defendant builds up and blocks the plaintiff's solar panels from the sun. So the defendant builds up, casts a shadow over the plaintiff's property. This blocks the plaintiff's solar panels. Right, plaintiff is unhappy about this. It goes to court suing the defendant. Now, right at the beginning of Justice Abrahamson's judgment, he says the following. He says, "This appeal presents an issue of first impression." Okay, first question, what does that mean? What is an issue of first impression? An issue of first impression is an issue that hasn't been before the courts before. So there's no settled precedent on the matter. The court can't settle the dispute between the parties merely by an appeal to precedent. The court has to develop the law in a way to answer the question. So Justice Abrahamson says this is an issue of first impression. This issue has not come before the courts before. Now, that might surprise you because you might think we have seen cases just like this. I mean, for one thing, isn't this case quite a lot like Fontainebleau? Defendant builds up, casts a shadow, and so on, right? But why is it that Abrahamson thinks this case is a case of first impression? Well, we can see his answer if we just continue a little bit further. He says, "This appeal presents an issue of first impression, namely, whether an owner of a solar heated residence states a claim upon which relief can be granted when he asserts that his neighbour's proposed construction of a residence, which conforms to existing deed restrictions and local ordinances, interferes with his access to an unobstructed path for sunlight across his neighbour's properties." So this tells us why, for Abrahamson, this is an issue of first impression, because for him it's not about access to sunlight in general or the right to build up in general. This is specifically a case about solar energy. Okay, and because it's specifically about solar energy, for this judge, Fontainebleau is not relevant because Fontainebleau is about sunbathing. Okay? So because the court identifies the issue this narrowly, an issue about solar energy, then this is a case of first impression, a case of a kind that hasn't been before the courts before. Furthermore, consider this. Abrahamson says, in every case, the court must make a comparative evaluation of the conflicting interests according to objective legal standards, and the gravity of the harm to the plaintiff must be weighed against the utility of the defendant's conduct, which is a reference to a very famous, very influential textbook in the United States. Okay, so what Abrahamson says here is, look, when we're deciding whether the defendant's activity constitutes a nuisance, we have to look at the utility of the defendant's behaviour, and that means its social benefit. We have to do a kind of cost-benefit analysis and work out whether it's a good thing from a cost-benefit perspective that the defendant is allowed to do this. Now, here you might stop again and ask, well, what did Fontainebleau say about this? What did Fontainebleau say about these kinds of considerations? Well, we remember what they said. The court in Fontainebleau said these may be important matters, but they are to be left for democratic decision makers. They are to be left for local councils or what have you. Democratically elected decision-making bodies to determine. It's not the job of the court to determine this. But this court sees things completely differently. This court says, no, this is precisely our job. Our job is to work out whether it's a socially advantageous thing to allow the defendant to build up. Okay, and now remember also what Fontainebleau said about the right to sunlight. They said there wasn't one. What does this court say about sunlight? Abrahamson says, access to sunlight as an energy source is of significance both to the landowner who invests in solar collectors and to a society which has an interest in developing alternative sources of energy. And he footnotes, state and federal governments are encouraging the use of the sun as a significant source of energy. In this state, the legislature has granted tax benefits to encourage the utilization of solar energy. The federal government has also recognised the importance of solar energy and currently encourages its utilisation by means of tax benefits, direct subsidies and government loans for solar projects. Going on, courts should not implement obsolete policies that have lost their vigour over the course of the years. The law of private nuisance is better suited to resolve landowners' disputes about property development in the 1980s, when this case was decided, than as a rigid rule which does not recognise a landowner's interest in access to sunlight. Okay, so what we see here is we're not going to have a general rule about whether one has a right to access to sunlight or not. The court will say that a particular plaintiff has a right to access sunlight depending on the court's assessment of the utility, that is, the social costs and benefits. Now, as part of his argument, Abrahamson presents the following claims. He says, look, the law in the 19th century was based on a strict right to be able to build on your property, coupled with the idea that there was no right to sunlight. And he says that this rule was based on three policies. First of all, the idea that you needed to protect property rights. So the courts were very strict about the protection of property rights. Secondly, they felt that sunlight was of aesthetic significance only. So sunlight was only valuable because it was it looked nice, it felt nice, and that was all. And thirdly, because the courts were trying to promote land development. They were trying to incentivize land development, and so to give those who were building on their property an unrestricted right to do so, or relatively unrestricted right to do so, was held to be in accordance with that policy. Okay, and what Abrahamson's saying is, well, that may have been well and good for the 19th century, but certainly in the later 20th century, things are different, right? We live in a different world, different policies apply, and so we need a different law. Now, one of the things I'd like you to notice about this is that when Abrahamson makes this argument, he doesn't cite any cases, right? He doesn't provide any evidence to suggest that these policies were being advanced by 19th century judges. He simply assumes that it's true that the 19th century judges were advancing such policies. And this is a style of argumentation that you'll become accustomed to as you study law. That is, we don't say, well, look and see what the judges were doing. We say, oh yeah, whatever they said they were doing, what they were really doing was this. So when you look at the judges in the 19th century, they don't look as if they're advancing these three policies. But Abrahamson is saying, yeah, but they really were, right? They didn't tell you that they were doing it, but they really were. And this general approach is known as legal realism, right? It's known as realism because the idea is we're telling you what the judges were really doing, right? Not what they necessarily said that they were doing. Now, for what it's worth, and I might as well just come clean on this at the moment, I don't find this position really attractive at all. I don't think there's any reason to believe that the judges were systematically lying about what they were doing. But nevertheless, this is a position that many intelligent, talented people have held. So it's something that you should keep in mind and ask yourself as you go along whether you think this is right. Are the judges sort of hiding their reasons? Are they really implementing these kinds of policies? Or are in fact the reasons for their judgments presented in their judgments? I mean, think about Bramwell, for example, in Bryant and Lefevre. According to Abrahamson and people like Abrahamson, what Bramwell was really doing in Bryant and Lefevre was trying to advance policies of this kind. My question for Abrahamson and others would be, didn't Bramwell actually tell us what he was doing? Can't we see what he was doing just by looking at his judgment and reading it? Isn't he actually being honest with us? Even if we don't agree with what his conclusions are, maybe we don't, maybe we do, maybe we don't. But even if we don't agree, can't we see just from his judgment what he was doing? Do we need realism to explain what was going on in those cases? Anyway, that's just something to bear in mind. The result in Pryor and Moretti then is this. The judge says we want solar panels in society. They're a good idea. They produce an alternative source of energy. It's something that we want to encourage. What the defendant is doing is getting in the way of this, and so we're going to say that the defendant committed a legal wrong. And in support of this, as we have seen, the judge points to legislation promoting the use of solar energy. Now, I need to explain that none of this legislation said that what the defendant's doing is a nuisance, right? It wasn't as if there was legislation that said if you build up and block a solar panel, that will be a nuisance. If that was the case, there'd be no issue here. The legislation didn't do anything like that. It just promoted the use of solar panels. And so Abrahamson is not saying, look, the legislation says this is a nuisance. Abrahamson is saying, look, the legislation says that the use of solar energy is a good thing, right? And so I'm using that fact in my assessment of the benefits and burdens, the cost-benefit analysis, my assessment of utility, to come to the conclusion that the defendant's activity was a nuisance. It was a nuisance because it interfered with a socially beneficial activity. Okay, the plaintiff wins. That's Pryor and Moretti. Now for our next case. Okay, so Catelli and Lincoln Trust. Here, the defendant builds up, and as a result of building up, an increased amount of snow falls on the plaintiff's roof. And this is a problem for the plaintiff because as a result of the extra weight of the snow, the plaintiff has to get the roof reinforced, and he doesn't want to have to pay for it, right? He wants the defendant to have to pay for it and goes to court claiming that the defendant was guilty of committing a nuisance. Now, just something that we could have raised earlier, but may as well come up now. Notice in this case, as opposed to, say, Fontainebleau, the plaintiff is seeking damages rather than an injunction. Okay, because the house has been built up, he just wants damages to pay for the cost of reinforcing the roof. Now, this is not important for us. It doesn't matter to us at the moment. We'll look at cases where this issue becomes important. But for the moment, this issue isn't relevant to us because in order to recover damages or to get an injunction, the plaintiff needs to show that the defendant has committed a legal wrong, has committed a nuisance. And that's the issue that we're focusing on here. Is this a nuisance? Right? And in order to get damages or an injunction, that question has to be answered in the affirmative. Okay. All right. So, defendant builds up, causes more snow to fall on the plaintiff's roof, to accumulate on the plaintiff's roof. Plaintiff has to reinforce the roof, wants the defendant to pay. Is this a nuisance? What does the court say? First of all, the court says this. There is, in my view, in cases such as this, a good deal of legal advantage in being there first. Okay, so here we see that, according to the court, who got there first matters. The plaintiff got there first, in the sense that the plaintiff was already there living in the house and so forth before the defendant built up. So the plaintiff got there first, and that makes a difference. Going on. In the case at bar, the plaintiffs constructed their building taking reasonable precautions and reasonably not expecting a building such as the defendant's as its immediate and adjacent neighbour. The defendant, Lincoln Trust, on the other hand, knew before construction of the existence of the plaintiff's building and that the planned construction would inevitably cause damage. Surely it was incumbent upon Lincoln Trust to take steps to prevent that damage. Okay, so what the court is saying here is that the defendant knew that its building up might cause some damage to the plaintiff, and they went ahead anyway, or they should have known if they didn't know, and they went ahead anyway, and so they should be liable. Now, the language here is very important to see, although at least for those of us who are approaching law for the first time here, particularly those who haven't discovered the law of negligence yet, it might be difficult to see this, but the language that the court is using here is the language of the law of negligence. The court talks about what was reasonable, what could be foreseen, what ought to have been foreseen. And the court is claiming that the defendant should be liable because it acted unreasonably, whereas on the other hand, the plaintiff acted perfectly reasonably. Now compare this with previous cases in which the courts have said that negligence plays no role in the cause of action. Here, Justice Grange is saying that actually negligence determines the matter. Right? The fact that the defendant was negligent, at least in this judge's eyes, means that the defendant is liable. Okay, so first of all, it matters who got there first. The plaintiff got there first. Right? Second, the defendant was negligent. Negligence matters. The defendant was negligent. The plaintiff was not negligent. Therefore, the plaintiff wins. Next case. Okay, so our next case is Hunter and Canary Wharf, a decision of the House of Lords. I mean, I think it's fair to say that this is probably the most important nuisance decision to come out of a Commonwealth court in the last, let's just say 50 years. That's probably being a bit unambitious, but anyway, there we go. What happens in this case is, this is part of a redevelopment of the Docklands area of London. As part of this process, the defendants build a tower block. So they build up on their land, and this causes the plaintiff's television reception to be blocked. Now, there's some debate in the case as to whether the interference with the plaintiffs could constitute a nuisance. That is, can interference with television reception constitute a nuisance? And the court agrees that it might. Maybe not. It probably wouldn't now, because if you think about it, I mean, who actually watches television anymore? And those of us who do, how many of us get it? I mean, everyone's watching YouTube, right? How many, those of us who do watch television, how many get it through in the way that the plaintiffs did in this case, that is through transmission towers? Yes, lots of people get it through cable or whatever. Anyway, the court is prepared to accept, at least for the sake of argument, that interference with television reception can constitute a nuisance. Nevertheless, the court comes to the conclusion that the defendant was not committing a nuisance in this case. But the key thing for us is to see the different ways in which the different judges come to this conclusion. There are really for our purposes, two main judgments in the case. The judgment of Lord Gough on the one hand and the judgment of Lord Cook on the other. They couldn't be more different. Lord Gough says, simply, it can't be a nuisance because the activity that the plaintiff is complaining about is building. And in a case of this kind, building simply, unless it causes physical damage to the plaintiff's property, building cannot constitute a nuisance. As he says, as a general rule, a man is entitled to build on his own land, though nowadays this right is inevitably subject to our system of planning controls. As Lord Justice Linley said in Chastity and Ackland, a case concerned with interference with the flow of air, speaking generally, apart from long enjoyment or some grant or agreement, no one has a right to prevent his neighbour from building on his own land, although the consequence may be to diminish or alter the flow of air over it onto land adjoining. So to diminish a flow of air is not actionable as a nuisance. Okay, so what Lord Gough says is, unless you're causing damage to someone's property or something like that, you have a right to build on your property. And if that blocks television reception, well, it blocks television reception. People have a right to build on their property. And as a result of this, it can't be a nuisance to do what the defendants did. Now, Lord Gough also recognises, as indeed we see in the passage already quoted, that there may be public policy arguments that run the other way, but Lord Gough says that's not a matter for the courts to determine, that's a matter for the appropriate public authorities to determine. As he says, if a large building is proposed in a neighbouring area, it will usually be open to local people to raise the possibility of television interference with a local planning authority at the stage of the application for planning permission. Okay, so that when the defendant built this, they had to apply for planning permission in the way that anybody else would have to apply for planning permission when constructing projects of this kind. And that was the right stage to have concerns about television reception of public policy issues debated. Not in court, but at planning permission stage. As it turns out, the planning authority allowed the building to go ahead, so that's the end of the matter, says Lord Gough. Now, Lord Cook comes to the same conclusion, but does so for really radically different reasons. Where Lord Gough said the public policy arguments are for democratic institutions to determine, or public authorities to determine, Lord Cook says, no, they're for me to determine, right? They're for the court to determine. The court's job is to determine the public policy arguments. And so I won't go through his judgment. I mean, you have to read it because it's quite detailed, because this takes him quite a long time to work out. But Cook asks himself, was the defendant's building up reasonable, where reasonable means, was it socially beneficial? Was the defendant's activity a socially beneficial thing that the courts ought to support? And his answer is that yes. I mean, there are, for a number of reasons. One reason the answer is yes is because this was part of a regeneration project. I mean, you can see some pictures here. This is what the Docklands area of London used to look like, and after the regeneration, this is what it now looks like. Okay, so you can see there's been a regeneration. This was a rundown area, and now it's been regenerated. There are new buildings there. There's more activity there, and so on. This is all a positive thing. So what the defendants were doing was something that we should encourage. Therefore, it wasn't a nuisance. He also argues that the defendants behaved reasonably because they acted in accordance with the planning permission that they were given by the planning authorities. And he argues that it was government, in this case, council policy to undertake this regeneration project. So, all in all, Lord Cook says, look, this was a good thing for society, right? The defendant's activity was a good thing for society, right? The court should be encouraging it, not preventing it, not damaging it, right? Therefore, it wasn't a nuisance. Now, you might also note, though, that this approach was very soundly rejected by Lord Hope. Now, at this point, you may well be wondering what the heck is going on, right? Every year, I teach this subject first when I teach tort law, and every year I can tell, I look out amongst the sea of faces and I just see confusion and worry. And the reason is that students, when they come to law, they generally expect things to be relatively neat and tidy. You know, maybe there'll be a few frayed edges here and there, but basically things will be clear. Like, you learn the rules, you apply them, it's simple. They didn't expect there to be this degree of disagreement and this degree of contradiction in the case law. But the truth is that this is what the reality is like. There is this amount of disagreement. There is this amount of confusion. There is this amount of contradiction. And one of the things about learning tort law that makes it difficult, but also interesting and at least to weirdos like me, exciting, is precisely that there is this degree of disagreement and confusion and so on. It means that we don't have to simply be learning the rules by rote and applying them. It means that we've got a job here to figure out what we ought to be saying about this, right? It's not as if it's all laid out for us by somebody else and we just have to walk down the path that someone has laid for us. There are many paths that have been laid for us by the judges, and they lead in different directions. And part of our job as students of the law is to work out which of these paths are the right ones, and if any, right, and which are the wrong ones. Okay, now, so what are we to make of, let's just focus on the 5 cases that we've studied. I say in a way 6 cases because you can treat Hunter and Canary Wharf as 2 different judgments, if you like. One goes one way and one goes the other, right? They come to the same conclusion, but for very different reasons. So what are we to make of this? What are we to make of all this disagreement? Well, one possible approach is to simply treat each case as laying down a separate rule of law, and on this basis to hold that they're all consistent with each other in some kind of strange way. So you might say, for example, imagine that we lived in a jurisdiction where all these cases were precedents. We might say, for example, well, okay, it's not a nuisance if you're interfering with sunbathing. It's not a nuisance if you cause fire to smokes. It is a nuisance if you block solar panels. It is a nuisance if you cause snow to build up. But it's not a nuisance if you interfere with television reception. Okay, now you may have been encouraged to think this way by various media and so forth. This is the way the law works. It works in this kind of very piecemeal, rule-bound way. One rule applies to this case, one rule applies to that case, one rule applies to the next case. And you can approach the cases in this way. But my suggestion is that this can't be the right way to think about the common law. Statute law may work this way, but the common law can't work this way. And the reason that it can't work this way is because it must operate in accordance with general principles. That is, the reasons that it gives for its judgments can't apply simply to particular areas. They have to apply generally. And this is the problem. The problem here is that the idea that what we have here is a whole bunch of consistent cases, they're just, the rules just apply to the particular case to which they apply, is inconsistent with what the judges say. Right? This understanding of the cases is inconsistent with the reasoning that we find in the cases. So, for example, we can't simply say that Bryants and Lefevre is a case to do with fire smoking and Catelli is a case to do with sunlight, because in the first case, the judge said it doesn't matter who got there first, and in the second case, the judge says it does. Well, does it matter or doesn't it? It can't be. It doesn't make any sense to think that who got there first doesn't matter when there's a fire smoking, but it does matter when there's snow. I mean, why? Why would that be the case? And also, say, in Fontainebleau, the court says that unless there's been a violation of a right, there can't be a nuisance. In Pra and Moretti, the court wasn't interested in the rights of the plaintiff. The court didn't say the plaintiff had a right to sunlight. The court simply said it's socially advantageous that the plaintiff uses solar energy. That's a totally different kind of argument. Also, as we've seen, we've got strict liability reasoning in cases like Fontainebleau and Pra and Moretti. That is, negligence, remember, is supposed to be irrelevant. But in a case like Catelli, negligence is what determines the issue. So again, we've got this inconsistency. Some courts say negligence is irrelevant. Some courts determine whether there's a nuisance by looking at issues of negligence. In any case, I put it to you, I suggest my viewers, it'd be ludicrous to think that each one of these cases is just relevant to its particular set of facts. I mean, the idea it's a nuisance if there's solar panels but not if there's sunbathing, that's just bizarre. Or it's a nuisance if there's snow but there's not fire. That's just crazy. That's totally capricious. And the common law can't operate in this way. Ideally, statute law doesn't operate this way either, but I suppose it could. Right? But the common law can't be capricious in this manner. Now, I've got some rather hokey diagrams here that I'm trying to use to demonstrate a point here. Now, I want to say, before I start this, that these diagrams are hokey for two reasons. The first of all is that I'm completely useless at anything remotely related to art, so I can't really do any better. But the other reason is I think I'm trying to actually simplify them to the most basic understanding of these cases that we can get, and so that I don't want the diagrams to be full of impressive detail, because then you may miss the point. The diagrams are supposed to be as simple as possible, and that's why they're kind of stupid. Stupid, but I hope effective. Okay, so here's our first diagram. This is Fontainebleau. So there's this, and just a little key. The key here to understanding my diagrams is that the blue is the plaintiff, the red is the defendant, and the green. There isn't any green in any of these, but there will be in some later. The green is third parties. Okay, so here we have the defendant and the plaintiff side by side. There's the sun. What happens? The defendant builds up. How different is that from this case? Right. First of all, then defendant builds up. How different is it? It's the same case. It's just a few details are different. Or think about Bryants and Lefevre. So here we have a case, defendant builds up, chimney smokes. How different is it from this case? Snow. More snow. these are the same cases, right? These cases are identical. To say that they're completely different seems to me to entirely miss what these cases are actually about. These decisions are inconsistent. A legal system that contained them would be incoherent. Right? We are offered here a choice between two approaches. We have Fontainebleau, Bryants and Lefevre, and Lord Gough's judgment in Hunter and Canary Wharf on one side, and we have Pryor and Moretti, Catelli, and Lord Cook's judgments in Hunter and Canary Wharf on the other side. These are two different approaches to understanding law, and we are going to have to choose between them. Okay, well, we're not going to choose between them yet. What I want to do now is more carefully identify what I take to be the key features of these two ways of understanding the law, or what I'm going to call two models. Now, before we begin that, I just need to say that the terminology that I'm going to use here is, well, it's not mine, it's terminology that I've swiped from the person who taught law, Professor Ernest Weinreb at the University of Toronto. We understand what these terms mean, but that's no guarantee that anybody else will. These are just terms, you're not going to find them in case law, you're not going to find them in textbooks, but these are terms that I think will help you understand what's at stake in the debate between these two models of understanding law. Okay, now the other thing to say is it'll soon be obvious to you, if it isn't already, which model I prefer. But as always here, the task is not to get you necessarily to agree with me, although of course you should because I'm right, but to get you to make up your own mind about this. Okay, so I'm going to push a particular model. I'm going to try and give you reasons for thinking that a particular model is better than the other one, but you should always treat these arguments as simply as that, the arguments of a person, just of me, right? And you're always welcome and always invited to disagree with them, or at least to take them critically, to think, is Beaver right about this, or is he getting this wrong? Okay, all right. Okay, so the first model is what I call, or what Ernie calls, the advantages model. The advantages model. And according to this model, the way to determine a case is to look at the advantages of going one way or the other. And Pryor and Moretti provides a pretty obvious, pretty clear example of this. How do you work, according to Pryor and Moretti, according to Abrahamson in that case, how do you work out if the defendant's activity was a nuisance? You look and see what the social advantages are of the party's behaviour. And in that case, Abrahamson thought that the plaintiff's activity, the use of the solar panels, was more socially advantageous than the defendant's activity, so the plaintiff won. Okay, so on this approach, you determine the case by looking to the advantages. Which outcome will best benefit society? Okay, now those who appeal to this kind of argument, or those who operate on the basis of this model, place a large emphasis on what's known as policy. Now, this is a very tricky word, the word policy. It can mean all sorts of different things. Sometimes when judges use the word policy, they're just referring to the way the law works. But sometimes they mean what's often called public policy. That is, working out what's best for society as a whole. Okay, and we saw this with Abrahamson's claim that in the 19th century, the policy was protect property, sunlight's just of aesthetic value, and so on. Whereas in the 20th century, our policies are different. We need alternative energy and so on. Okay. Now notice that in this approach, there's no appeal, or there need be no appeal to the law to determine the outcome. So when we're looking at the social advantages, right, we may or may not look to the law. In fact, often we won't look to the law. I mean, what we're looking to is the best use of resources, right? And as a result, the information that may be most useful to us will come from outside the law, or might come from economics or some kind of social policy analysis, right? Now in Pryor and Moretti, remember that the judge did look at legislation, but recall that that legislation didn't say that it was a nuisance to do what the defendant did. The legislation simply said that it was, or gave the legislation gave the judge evidence to hold that the plaintiff's activity was socially advantageous. Okay, so judges who reason according to the advantages model try to work out what the law's policy should be by looking to the advantage of society as a whole. This fits with Pra and Moretti. We want solar energy, it's good for society, plaintiff wins. It fits with Catelli. We don't want people to build up in a way that's going to cause problems for their neighbours. The defendant should have known, and so on. So that's one model, the advantages model. The second model is what Ernie and I call the rights model. Now, on this view, the approach of the court is not to determine what's advantageous for society as a whole, not to work out what the best public policy arguments are. The job of the court is to determine the result by looking at the rights of the parties. So at the legal rights of the parties. So the focus here is not on society as a whole, right, but on the two parties before the court. The court is to determine the issue by looking at the defendant's and the plaintiff's rights and working out on that basis who wins the dispute. The dispute is to be settled in an interpersonal fashion, not in a societal fashion. Now, a good example of this is found in the little extract I've got in the materials from a case called Hay and Cohos, a decision of the New York Court of Appeal, where the court says, "It is an elementary principle in reference to private rights that every individual is entitled to the undisturbed possession and lawful enjoyment of his own property. The mode of enjoyment is necessarily limited by the rights of others, otherwise it might be made destructive of their rights altogether. Hence our friendly maxim. If rights conflict, it is better that one man should surrender a particular use of his land than that another should be deprived of the beneficial use of his property altogether." So this is a classic example of the application of the rights model. The court says when we've got a conflict between the plaintiff and the defendant, the way to determine it is to work out whose use of land is the more general, whose use of the land is the more particular, and the more particular use will have to give way to the more general use. All right, so this is an approach that settles the issue by looking at the two parties to the dispute and determines the case that way. Now, as we've seen, there may well be public policy considerations that also need to be taken into account, but they are to be taken into account on this approach by democratic institutions, not by courts. Okay, now, so this idea of particular and general, we'll see in a later case that, again, our friend Bramwell, Baron Bramwell in that case, says the distinction here is not general peripheral, but ordinary and extraordinary. My preferred approach, and this is just my suggestion, I think this is the best way of understanding this area of the law. You won't find this in the case law, but it's my suggestion that the best way of understanding this is to focus on a distinction between fundamental and peripheral, with the idea being that more fundamental uses of land trump less fundamental uses of land, or more peripheral uses of land. And by fundamental, I mean at the core of our understanding about what property is about. So if we're in a conflict and you're saying my use of my land is interfering with your use of your land, if you can show that your use is more fundamental, closer to the core of what we understand property to be, then you'll win. But if I can show that my use of land is closer to the core of what we understand property to be, then I will win. Okay, so just to take some examples from cases that we've already studied, remember St. Helens Smelting Company in Tipping, smelter producing a vapour that causes damage to the plaintiff's property. Well, which is more fundamental, to have property that isn't being damaged or to run a smelter? Well, it's to have property that isn't being damaged. Plaintiff wins. Halsey and Esso Petroleum, acid smuts and oily drops causing damage to property. Same thing. Which is more fundamental, to run an oil depot or to have your property not being damaged. To have your property not being damaged. Okay, plaintiff wins. What about the noise, particularly the noise at night? Now remember what Justice Fields said in that case. It's part of the essence of having property. Part of the very reason for having property is that people can sleep in it at night. That's very fundamental to our understanding of what property is about. That trumps running an oil depot. Plaintiff wins. But what about then Fontainebleau? What is the defendant doing? Building up. What is the plaintiff doing, or the plaintiff's patrons doing? Sunbathing. Which is more fundamental to property? Being able to build on it, or sunbathing? Being able to build on it. After all, the plaintiff wouldn't have a pool or a cabana area if the plaintiff hadn't built on its property. Building up is more fundamental than sunbathing, right? Defendant wins. Bryants and Lefevre, which is more fundamental? Building up or having a fire that doesn't smoke? Well, building up, because if the plaintiff hadn't built up, the plaintiff wouldn't have a fire that smoked. Which is more fundamental? Hunter and Canary Wharf, building up or watching television? Well, building up, because if the plaintiffs hadn't built up, or the people hadn't built that property, the plaintiffs wouldn't have a room to watch television in the first place. Okay, the ability to build on one's land is a very fundamental aspect of property. It's much more fundamental than lying in the sun, sitting around a fire, making hot water, whatever, right? And so it is going to trump other uses of land unless the building up causes damage to the plaintiff's property, right? In which case it would be a different situation. Now notice that this is not a policy analysis. I'm not saying that the person with the most fundamental use wins because social policy requires it. Maybe social policy doesn't require it. Maybe social policy requires bylaws to be passed in order for different results to be reached. I'm saying that the most fundamental use wins because it's the most fundamental, right? This is a rights analysis. The party whose right is the most fundamental succeeds. The policy analysis is left for other people to determine. Okay, this is what I would call a principled approach to the law, not a policy-based approach to the law. Okay, now, you can't go to court and say, my client wins because his use is the most fundamental. That's not the language that the court uses. The courts in our jurisdictions talk about reasonable use of land. I will come back to this. It seems to me, however, that to talk about reasonable use of land is pretty much useless, because there are lots of cases in which it looks as if, for example, the defendant's use is perfectly reasonable and yet the defendant loses. It seems to me that if you want to understand this area of the law, thinking about fundamental use versus less fundamental or peripheral use is very useful. It's a key to unlocking what's going on in this area of the law, even though the courts don't themselves, the judges themselves, don't actually think this way. Now that's my view. It may be wrong, but just my advice is to think of it as you go through the cases. Think of it, is the plaintiff's use more fundamental here or the defendant's use? And I think if you do this, you'll find it helpful in developing your understanding of the law. Okay then, to summarise where we've got to so far. In each of the cases we've looked at, there's a conflict between the plaintiff and the defendant. The plaintiff says, I want to use and enjoy. Remember, what is a nuisance? An interference with the use and enjoyment of land. The plaintiff says, I want to use and enjoy my land, but I can't because of the way that the defendant is using his land. The defendant is interfering with my use and enjoyment of land. Now, the defendant comes to court and says, but I want to use and enjoy my land. If you find for the plaintiff, you are going to allow her to interfere with my use and enjoyment of my land. Okay, now what is the court to do? When there's a conflict of this kind, what is a court to do? The law of nuisance is concerned with protecting the use and enjoyment of land, but there are two parties here with the same basic claim. He's interfering with my use and enjoyment of land. If you find in favour of her, she will interfere with my use and enjoyment of land. What is a court to do? which use and enjoyment of land is the court to protect? As we've seen, there are two approaches to solving the question. Whose use of land is going to win out over the others? Two approaches. One approach is to look to the social costs and benefits. The person wins whose position most accords with the interests of society. On the rights model, things are a bit more difficult. We have the idea that a nuisance is an interference with the use and enjoyment of land. So here what happens is someone will not be able to use and enjoy their land as they would like to. So what are we going to do? We're going to protect those uses and enjoyments that are fundamental to the notion of property over those that are less fundamental to the notion of property. The answer on this approach is to tie the resolution of the conflict to the concept of a nuisance. And this is really important. It's great if you can see this. Right, on the advantages model, what's a nuisance, or whatever's not in the public interest. On this model, what counts as a nuisance is determined by reference to the concept of what a nuisance is. What is a nuisance? An interference with the use and enjoyment of land. What do you do when there's this conflict in use and enjoyment of land between the plaintiff and the defendant? You determine who wins by looking at whose use and enjoyment of land is the most fundamental. The solution to the dispute, the resolution of the dispute, is found by focusing on the concept of nuisance itself. So building up Trump's sunbathing, building up Trump's lighting fires, building up Trump's watching television, and so on. Okay, now this tension between the advantages and the rights model is something that we are going to see come up again and again and again in our study of private nuisance. But it doesn't stop there. It's not unique to the law of private nuisance. We'll find it throughout the law of tort. There's this constant tension between the rights model and the advantages model. And it's not confined to the law of tort. It's found throughout the entire law. And so I hope that this episode, this lecture, if you like, has given you some tools that will help you not only understand what's going on in these 5 cases, not only understand what's going on in the law of private nuisance as a whole, not only understand what's going on in tort law, but help you understand a very fundamental tension in the law in general. It doesn't make all problems go away. It isn't going to make everything simple, but hopefully it makes the confusion easier to understand. That is, if you can understand the basis for confusion, hopefully the confusion less looks confusing to you. Anyway, that's my hope. Okay, cheers. If you found this episode useful, please hit like, and if you could benefit from other episodes, hit subscribe. Thanks very much, and I'll see you next time. Cheers.